Ignoring calls, texts and emails from your boss after hours could become a legal right under a proposed amendment to Fair Work laws. The right to disconnect draft legislation will be up for debate in Parliament next week, with the amendment drawing sharp criticism from business groups.
Innes Willox, Chief Executive of the Australian Industry Group, says the change would be significant and has not been properly scrutinised. He joins us now from Melbourne. Good morning to you, Innes.
Morning, Kath. Hope you're well.
I'm really well, thank you. And I'm very aware that this is a Sunday and I've invited you to join me on the program, which is out of usual business hours. I hope that's okay.
That's all right. That's what I'm here for. But,
okay.
Yeah, this is an interesting topic.
It is indeed. So this right to disconnect, it's laws that essentially stop bosses or colleagues from contacting workers out of hours, within reason, obviously. It sounds fair enough, doesn't it, given that people have a right to their privacy, have a right to switch off to family time?
Well, Kath, this has sort of come out of the blue almost for employers. This is a Greens proposal that was put forward by the Greens, and it's a virtual carbon copy of what is occurring in France, which was introduced by the socialist president Francois Hollande right at the end of his term in 2017, the right to disconnect. The issue that employers have is that this hasn't been properly scrutinised. There hasn't been any real consultation around what it would mean. That in a lot of awards already, there is provision made around the ability for workers to either not be connected or to be connected after work because of the nature of their work. And there's already provision within the Fair Work Act for people to take complaints and concerns to the relevant agencies, the Fair Work Ombudsman and the Fair Work Commission. So the concern is twofold. This would just add more complexity and rigidity to workplaces, and it would break down trust. There's a lot of flexibility that operates both ways here. Think of the employer who says to their employee, yeah, you can go home half an hour early because you've got to go to the doctor, or you can turn up late because you've got to pick up your kids. That flexibility works both ways. Of course, if somebody's being forced to work out of hours and not being paid for it, that is an issue of concern, and employers shouldn't do that, but there are already remedies in place. So our concern here, Kath, is that this is more rigid, more inflexible, and will make workplaces more difficult. We're trying to operate in a more flexible workplace environment, work from home and the like. So there's got to be give and take here.
Yeah, you mentioned that there are remedies in place, but are those remedies enough? Do the provisions within the award system or the EA and Fair Work cover enough? Senator Barbara Pocock says at present there is no limit on how much an employee can be contacted, and there needs to be a reasonable approach. So if everyone's not covered within the current system, doesn't it need to be looked at?
Well, I think this is a solution to a problem that very rarely exists, and there hasn't been a lot of evidence that this does exist on any sort of widespread or consistent scale. So that's the issue here. We're trying to address a problem that doesn't really exist. Workplaces are a lot about give and take, and employers understand that they have to work with their employees as well. But think of some scenarios under this, what is proposed. If your dog's at the vet and is ill, then it would be improper or almost illegal for another vet to contact the vet who was looking after your dog during the day to check on an issue. If you need to tell your kid's teacher that they're sick in the morning and just drop them an email, that's not allowed either. If you're in Perth and you're trying to finish a pitch to a client, and you need some help from someone in Sydney and it's 4 o'clock in Perth, you wouldn't be able to contact the person in Sydney who's helping you because it's 7 o'clock in Sydney. So there's some real practicality that we have to work through.
And I understand and have listened to both sides of this argument looking at those practicalities. There could be carve-outs within this new legislation that's up to debate to allow for different time zones, different industries. I think what's being called for is just a more reasonable approach, because whilst you said it doesn't happen often, nevertheless it still happens. And I think the numbers are there's up to, on average, 7 weeks of time that is donated to Aussie workers. So don't those ones need to be made provisions for?
Well, Kath, as I said, when somebody is being made to work, unreasonably, totally unreasonably, and not being paid for it, that is something that should be taken up. The whole question is reasonableness here. And I was talking with, on radio this week with Sally McManus, the Secretary of the ACTU, and we basically came to the same conclusion. We've got to have a balance here. And the problem here, Kath, is that we haven't had any conversations or consultations around what it looks like. What does balance look like here?
Okay.
We've got to be real. We've got to be practical. And our issue is that this is sort of, as I said, come out pretty much from nowhere, and we haven't had a chance to have a look at it and work it through properly. And business employers would be deeply, deeply disappointed if this was picked up as part of other changes to the Fair Work Act next week without any consultation whatsoever.
So if consultation ensues, where would you find level of comfort if there were amendments to this? What would be reasonable if there were changes and if a right to disconnect legislation was to be amended into that Fair Work Act from 2009?
Well, Kath, I think it first has to take into account that there are already provisions within existing awards around this issue, and there are already remedies that are in place. The issue then is, well, what would be reasonable? What is reasonable? And in law, that's always the difficult thing. And then we'd have to look at carve-outs. What sort of carve-outs there'd be? This can't all be settled within potentially sort of 5 days until this legislation is possibly passed. That's just a ridiculous time frame. It's going to take time to work it out. I think employers understand and I'll reiterate, when people are not being paid for significant work out of hours, that's a problem and that shouldn't happen. But where do we strike the balance here? Does an employee just have a right when the fire alarm's going off at work and they've got the code to not answer the phone? Those sort of issues, we just have to work it through. So it's about balance, and we haven't really had a proper conversation about it.
Yeah, okay, reasonable. It's interesting, isn't it? It has different meanings for a lot. Innes Willis, really looking forward to seeing how this all plays out. Thank you so much for joining us here on Weekend Breakfast.
Have a great day. Thank you.